We'll call this meeting to order. First item of business is to stand for the pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let's see. First item of business is approval of the November 7th meeting minutes.
I move that we approve from November 7th.
Second.
We've got a motion and a second for the three of us that were at that meeting. Let's proceed to vote.
Weiss?
Yes.
Bright, I'll just put your present at the meeting today. Scorts?
Yes.
Remy?
Yes. First item of business is welcome Bob Wright, our new commissioner. If you haven't already met him, glad to have you on board. And it looks like we need to have an election of officers. Emily Waldron is not here this evening. If you don't show up, you could get elected, you know. Anyway, I guess I would entertain a motion for chairman, as far as, what's it called? Nominations, there we go. Nominations for chairman.
I nominate Robert Ream to continue as chairman of the commission.
We got a motion and a second. Make sure you push your button down so that it gets on the recording minutes, yeah. Any other nominations? This is probably the most informal part that we ever do. All right, let's go ahead and vote then.
Scorts?
Yes.
Weiss?
Yes.
Bright?
Yes.
Remy?
Yes. Now I'd entertain nominations for vice chairman.
Oh, wait, was that, sorry, point of order, Mr. Chairman? Was that just a vote for who was being nominated, or was that a vote for?
I knew you'd do that, wouldn't you, Patrick?
Sure, okay, so we closed the nominations and then vote, right, for chairman, yeah, so. So we've got
do
one
we need
nomination.
Do we need a motion to close nominations then? I hate this part.
So what I would recommend is that you open the floor for nominations,
Which we did.
and if you get more than one, then you can vote on them separately. But before you vote to appoint the officer, you should probably be sure that there are no further nominations.
Do you have to have a second to the nomination?
No.
Okay. So Jim nominated me, and there was a second to it, but we don't need that second.
Yeah.
So are there any other nominations? Hearing none, then we'll close nominations and vote on the nomination.
Yeah.
Scorts?
Yes.
Weiss?
Yes.
Bright? Yes. Remy?
Yes. He's working on his microphone. Okay, then I'll open the floor for nominations for vice president. I would nominate Katrina.
I also nominate Commissioner Weiss for vice chairman.
Are there any other nominations? Seeing none, let's close nominations and vote on Katrina for vice chair.
So what I would suggest then is that you entertain a motion to approve the nomination
Okay.
so that you have a second and then vote.
All right, entertain a motion.
Sure.
Second, anybody? I'll second it, I can do that. Poor Cheryl, she's just right in the way there. Proceed to vote.
Bright,
Yes.
Scorts,
Yes.
Weiss,
I suppose.
Remy,
Yes. Okay, next item of business. We've got an application for a conditional use permit and, oh yeah, we got to do the Historic Preservation Board and then Board of Adjustment Appeals. The Historic Board, well, I do have a letter here from Emily that said she would like to be on it. We had a member that was on it and they left town, and last summer somebody from the board contacted me, and so as to show that P&Z was still interested in it, I did attend some meetings. However, that was only as a public citizen. I told them I was not appointed yet. So if Emily wants to be on it, I guess I would recommend that we would appoint her. We would need a motion and a second.
So move to appoint Emily Waldron to the Historic Preservation Board.
Second.
And I guess this is just to recommend to City Council, and then they do the final appointing, but just to recommend to City Council. Got a motion and a second. Is there any discussion? Let's vote.
Scorts,
Yes.
Weiss,
Yes.
Bright,
Yes.
Remy.
Yes. And then we need 2 people. Is that right, on the Board of Adjustment?
I actually have a point of order on this because I have a question. In looking into whether or not I wanted to be on this board, I asked for the background for the board. I see nowhere where it says that P&Z commissioners need to be on the board. What I see, and what Cheryl gave me, it says, and somebody has a microphone on, I'm getting feedback. It says, the Board of Adjustments and Appeals shall consist of 5 members who shall be appointed by the City Council. Not more than 2 members may be current members of P&Z. So if there's some place that says we need to have 2 P&Z members on there, I would like to hear that, but I don't see it, because for the Historic Preservation Board, it says membership, a member of P&Z must be a member of this board, but I don't see that for adjustments and appeals, so I'd like clarification, please.
You're correct, and I think the reason they have tried to stick with 2 is because they have a difficult time getting applications from the general public, and so it was a convenient way to fill 2 of the 5 slots by having the P&Z appoint 2 of their members. But you are correct, there's no mandatory requirement.
So how many members are there now?
There are no P&Z members.
No. I mean, on the
in total.
historic, or on the,
Is it 3 or 2?
so there's 2 openings on the Board of Adjustments.
Yes.
Let me ask a further question then, because in this it says there shall be 2 alternates appointed as well. Do we currently have 2 alternates to the this board? We don't. We only have
No.
the 3 members.
We don't, and we've been advertising for several months,
All
in
right,
fact.
thank you.
And, yeah. And honestly, the Board of Adjustment doesn't meet that often, so sometimes it's hard to keep folks on it. And so, yeah, we were looking for members from the public, but, you know, P&Z has already has some qualifications that we would be looking for a Board of Adjustment. So if there are some volunteers, and basically same thing, it would just be a recommendation because it's council that needs to appoint the Board of Adjustment members.
Well, I guess I'd first ask for a couple volunteers then, if anybody'd want to be on it. Jim, sounds like you would be willing to be on it? No?
I would volunteer for that.
Okay, Bob would, Katrina? Do we need to have a motion then to go with our 2 volunteers?
Honestly, we just need letters of interest from the P&Z members that would like to apply for the Board of Adjustment. And we've already done the required background check, so I believe that's all our city clerk would need.
Okay. So they just need to submit a letter to Cheryl or an email saying they're interested in being on it? Is that? Okay.
Yes.
Thank you, Jim. I should put my glasses on to read this, I guess. Then the next item is a conditional use permit. And Rachel, I guess you're going to highlight us on that?
Public participation first, in case.
Oh, that's right.
Sorry.
Anybody in the audience care to make any comments on anything that's not already on the agenda? Seeing none, then let's move on to the next item. Which is the resolution under public hearings. But it says Nancy, but I assume you must be doing it, Rachel, then?
Yeah, Nancy is not able to make it tonight, so I'll be presenting it. Just waiting for one thing to come up on the screen. But while we're waiting for that, I'll go ahead and start.
And after she gets done giving us some highlights, then we'd ask if the applicant would step up and make some comments, and then we'll open the public hearing for or against.
All right, awesome. That works. Okay. Okay, so just to give you some background, the Southern Bluffs Owners Association, the HOA, is proposing a conditional use permit to allow it to lease its existing clubhouse, which is pictured here on the screen, if you can see it, out for a business or professional office. The existing building operates as the common clubhouse for the Southern Bluffs subdivision. While the HOA has not yet identified a specific use or renter, they are hoping to obtain a use permit before advertising the space for rent. The site is bounded on the north, east, and south by residential properties located in the Southern Bluffs subdivision, all zoned MH residential manufactured home district. To the west is vacant property, also zoned MH. The property is already built out with a clubhouse, and the proposal is to allow a portion of the clubhouse to be rented by a business unaffiliated with the HOA. Business and professional offices are considered conditional uses in the MH zone. Business and professional offices are defined in the land use code as business or professional office means a use where business, professional, or governmental services are made available to the public, including business office, an office for use by persons such as realtors, travel, advertising, or insurance agents, property managers providing both products and services, or the home office of a company that sells retail or wholesale products, which would be sold elsewhere, or provides professional services. Or number two, a professional office, which means an office for use by persons such as lawyers, architects, engineers, accountants, physicians, dentists, and other professionals who primarily provide services rather than products. Although it would be more typical for the conditional use permit to be applied for once an actual business has been identified, the HOA believes that it would be better to have the permit in place before it advertises the spot for rent. Any business that meets the definition above would be able to rent the space if the permit is approved. Here's a few issues explaining what criteria need to be applied to a conditional use permit. They're subject to conditions imposed upon the approval of the use that are designed to reasonably mitigate any adverse impacts upon surrounding properties. Both the Planning Commission and City Council shall use the following criteria, which I'll list, in reviewing conditional use permit requests. It's understood that certain criteria that I'm going to list may not apply to a particular application. The applicant shall adequately demonstrate that the applicable criteria have been met. Number one, the proposed conditional use is compatible with adjacent existing uses and other allowed uses in the zoning district. Such compatibility shall be expressed in terms of appearance, architectural scale and features, site design and scope, landscaping, as well as the control of adverse impacts, including noise, vibration, smoke, fumes, gas, dust, odor, lighting, glare, traffic, circulation, parking, etc. The proposed conditional use has incorporated design features sufficient to protect adjacent uses, including but not limited to service areas, pedestrian and vehicular circulation, safety provisions, access ways to and from the site, buffering, fencing, and site building placement. 3, all proposed accessory uses must demonstrate that they are necessary and desirable. All proposed accessory uses shall comply with the requirements of subsections F1 and 2 of this section. Undesirable impacts created by these uses shall be controlled or eliminated. Adequate public services such as streets, off-street parking, pedestrian facilities, water, sewer, gas, electricity, police and fire protection must be available without the reduction of services to other existing uses. Provisions for proper maintenance of the building, parking and loading areas, drives, lighting, signs, landscaping, etc. shall be provided. The proposed conditional use shall conform to adopted plans, hours of operation, policies and requirements for parking and loading, signs, highway access, and all other applicable regulations of this code and other applicable regulations. So the proposal is to provide space inside the existing clubhouse for a yet undetermined business or professional meeting the definition of business or professional office contained in the land use code. I'll go ahead and bring up just a site plan so you can see what the clubhouse looks like.
Anybody have any questions for Rachel?
Yeah, do you have any questions so far?
I've got a question
Okay.
for Rachel. May I, Mr. Chair?
Okay.
Yeah, go ahead.
I noticed that the city engineer requested a site plan showing parking and other things on there. Did that ever, was that ever received?
No, because we don't have, an actual professional wanting to rent the place yet. So the parking would be based on occupancy. So, so in the code, it's, I don't know off the top of my head, but we would, if the commission chooses to approve it, we would ask for a site plan and we would look at what it is that they're planning on doing and require parking accordingly.
May I follow up, Mr. Chair?
Pardon me?
Just another question related to that. Would that site plan show the location and size of the signage also?
Yes, we would ask for that. The sign code for the city is pretty lax. We allow.
Well, it seems like I read, am I reading the code right? It's about 1 square foot per linear foot of frontage of the building. So it'd be perhaps 60 square feet, something like 10 by 6.
Yeah,
I understand.
it could be. Yeah. So, yeah, we would take a look at that once they're able to find someone to rent it out and approve it according to our sign code standards.
So would that person then have to come back to us with a site plan?
No, it would be looked at administratively.
Yeah. Does that help?
Yes, it is.
Okay.
Any other questions for Rachel? Then we'd ask the,
Well, I've got a couple more things.
Sorry.
Okay. So just to let you know, yeah, we did include comments from our various agencies when we sent them out for comments, and Commissioner Bright mentioned, the city engineer. So the commission has 4 options as far as we can see regarding what you could do with this. You can recommend that the city council approve the conditional use permit for the property located at 801 Bluffs Boulevard, zoned MH as submitted by the Southern Bluffs HOA. You can recommend denial. You can ask for more information and continue the hearing on the application to a date certain, or staff is recommending option 4, that the commission can recommend that the city council approve the conditional use permit and state any conditions it feels which would be necessary. And we have some conditions. It's pretty standard laid out, but the first condition would be all requirements of utility providers, city departments, CDOT, and affected districts must be satisfied as outlined in the adopted city codes and other regulatory documents. Specifically, all improvements shall comply with the minimum requirements of the building code. And number 2, operation of any business shall be limited to businesses that meet the definition of a business or professional office as defined in the land use code in effect at the time. And number 3, prior to initiation of any business, a site plan shall be submitted to the city indicating any proposed signage and required parking. So, parking and signage must comply with the land use and development code in effect at this time. So that's it from me.
Okay, thanks. So I guess those kind of answer your questions, Bob, as far as the signage and stuff, that they got to comply.
Right. I saw that. It's just for my edification, perhaps in the future, if a site plan was included, then I could, I think it'd make it more easier to understand the placement of things and
Okay, yeah, and typically that would be the case, but the applicant wanted to go ahead because of the time, I think, that it takes to get approval. They wouldn't want to miss out on advertising for someone and then say, oh, hey, you have to wait 3 months before you can actually move in, so.
All right, thank you. Karen, applicant, would you like to address us, please? State your name and make sure you push the green button down.
I'll use this one, it works. My name is Karen Sheik, and I live in Southern Bluffs. I'm also the president of the Homeowners Association. We are coming to you to request that we have a conditional use commercial license for this facility because we are looking for ways to get it to pay for itself. In the past, the clubhouse, and still is, can be used by residents for parties and that kind of thing. We've also rented it out over a number of years to people outside of the community for graduations and family reunions and birthday parties and all that kind of thing. However, we have discovered through careful bookkeeping that it's not paying for itself. The cost of utilities and maintenance of the facility, we are not making enough money with that kind of a setup for us to actually be able to cover our costs. And so in an effort to make this a self-sufficient entity within the HOA, the board has looked at renting it out and hopefully covering the cost that way. Years ago, when the subdivision was first developed, it's my understanding that there actually was an insurance company that rented space in the clubhouse. And although I didn't live there at the time, those people who were involved with the development of that subdivision indicated that it worked very well. Obviously, the HOA board probably is even more concerned than perhaps the P&Z with having a business in there that is not going to be disruptive of the community and create issues. our desire is to simply be able to cover our costs, but not create a problem so that there's excessive traffic or other kinds of things that would interfere with the lifestyle and the community for those houses that are located in the area of the clubhouse. I will tell you now that when we do rent out for parties, I was asking Marilyn if she could remember. I can't just right off the top of my head remember how many people that clubhouse can accommodate based on the fire code, but many, many more people than would be using the clubhouse if it were rented out to a business. We have a decent-sized parking lot, and the HOA would certainly, the board would certainly be very careful in the businesses that they screen to make sure that they would be an asset rather than a liability. Katrina lives in the subdivision, so she might have some particular questions or some additional information that she might want to share with the board. And I'm happy to answer any other questions that you all might have.
Okay, thank you. Anybody have any specific questions?
I do.
Mr. Chair, before you do that, Katrina, I believe you were planning on recusing. I would recommend that you leave the dais and actually leave the room during this so they don't catch signals from your facial expressions.
I do. By the way, hi, Mayor. It's interesting being on the opposite side of the podium from you, so that's kind of cool. I have one question. It's a two-part question. One, have all the residents been notified of this, and is there any opposition?
You know, the people that we have talked to have not expressed concern. We haven't actually notified everybody at this point because it's moot until you all, you know, are willing to entertain the proposition of us doing that. As Rachel indicated to you, one of the reasons why we've chosen to wait until we could get the permit is that we had somebody who was interested, and it turned out that the clubhouse really wasn't a good fit, so I don't think it would have worked out in the long run. But with the lead time that is required to be able to get this done, we figured it was probably better for us to go ahead and see if it was even possible to get this change in zoning before we began to both advertise it and hold a meeting. So, as I said.
Okay, then a follow-up question to that. Then, if this does pass, will you then will all residents be notified at some point before a business comes to the clubhouse?
Yes, they absolutely
Thank you.
would be, yeah.
So, yeah, I guess my question also was along the same line. I was going to ask, was there a vote taken by the residents? But obviously not, if they haven't been notified.
No,
So
that
was it
isn't
just
gonna happen.
the board that decided?
I will tell you that we have floated this before the residents in previous HOA meetings to simply tell them that we are, and we have written it down and sent it out in letters to the residents that we are simply not covering our costs. And we've already had to raise our monthly fees and have told residents that will continue, that they will continue to be raised on an annual basis. Of course, we've gotten lots of pushback on that because, you know, nobody wants to have to pay more in fees. But the only way that it's sustainable for us to not raise them to higher levels is if we can get some of these things that are costing us money taken care of. So we've floated it. We haven't taken, Robert, we haven't taken a formal vote at this point. But I will tell you that at the meetings where it's been discussed, just kind of casually, that there hasn't been any pushback, that we haven't had a group of residents that have jumped up and down and said, we don't want you to do that.
So did the board have a motion then to pursue this?
The board, yes, the board is 100% in agreement to do this.
And I thought I saw somewhere the number of parking spaces. Do we know exactly how many are there? 12?
I think 12, yeah.
Okay. So when you do rent it out to like a wedding reception or something, obviously there's probably going to be more than 12. Where do they park then, in the street?
Well, sometimes they park in the streets, there's parking in front and to the side, and then in the parking lot. And sometimes when we have, when we have the clubhouse that's rented for an activity like a reception or family reunion or whatever, you can see a number of cars parked along the street. Now, I will also tell you that we haven't had concerns expressed by residents when that's happened. I don't foresee the parking being an issue with the business, because I think the board, as I said earlier, will be fairly discriminating with regards to who they will entertain as a possible renter.
All right. Any other questions for her? Okay, thank you. We'll now open the public hearing for anyone to speak for or against. Please step up to the microphone if you so desire. Seeing none, guess I would entertain a motion of sorts.
Mr. Chairman, before it goes to a vote, I just wanted to answer one thing that came up while Ms. Sheik was speaking.
Okay.
That's okay. So the city is required to, notify residents or businesses within 300 feet. So we did send, well, actually, I don't know if there are any within 300 feet, because it's a pretty big buffer. But we also did other notices that we normally do, like publish it in the paper. And so residents were notified in that way.
Well, yeah, I did notice that on the application. I thought, well, okay, that's about a football field, so maybe there were no residents within that
Yeah,
distance.
there were a few, okay.
Yeah, okay. So well, I guess we'll close public hearing officially. Any comments, motions?
I make a motion that the Planning and Zoning Commission recommend that City Council approve the conditional use permit for a business professional office at 801 Bluff Boulevard in the Manufactured Housing District submitted by Southern Bluffs HOA. Resolution number 1, Series 2024, with 3 conditions of approval contained in the resolution.
Second.
We have a second, motion and a second on the table. Any further discussion? Let's proceed to vote.
Scorts,
Yes.
Bright,
Yes.
Remy.
Yes. Let- Yeah. Yeah, all we do is recommend the city council, and then they have to decide on things. Most of the time, they take our recommendation, but not always.
I'm good with that.
Yeah. Next item on the agenda then is training by Patrick. You can do this for city council too, Patrick?
Good evening, Mr. Chair and commission members. I'm Patrick Coleman, the city attorney. I'm going to give you a short training on a few issues that I think may be pertinent to some of you. I hope this is one of many trainings that we do throughout the year, and I would encourage you, if there are specific issues that you may have an interest in or you think other commission members need to be advised of, that you submit those to Rachel, and we will come up with additional trainings throughout the year. So with that, we'll start with the first one, and please interrupt me if you need to, if you have questions. You have this presentation in front of you. You've got colored portfolios that may be easier to read than the statutory text on the screen. But I guess to get down to a very basic level, you know, why do we have a planning commission? Where is the authority for that? And it's required that municipalities, even home rule municipalities, have planning commissions. The statute 3123-202 requires it, and it can be created by ordinance or resolution. The city of Cortez created this commission by ordinance, and it's contained in the City of Cortez Code, Article 2, Section 2-4. And as you'll see, and of course this predated my time, and I suspect all of your time with your affiliation with the city, but it's created with 9 members, and 4 of those members are what they call ex officio members, which don't have voting rights. The mayor is one of them, the city manager is one, the city engineer is one, and the zoning director is one. I'm not sure why they did that, because if they don't vote, you know, I suppose they could offer their input either through the application process, which the city engineer does and the zoning and planning director does, but they can also come and speak as a member of the public if they choose to. I guess I have a thought about whether or not it's really even appropriate that the mayor, and no offense, Mayor, but as we'll get into later in the discussion about quasi-judicial hearings, the mayor technically is allowed to sit in on all the planning commission meetings, and then she's required to sit in on city council meetings where the same application will be heard in front of the council. And I think there's at least an argument that that conflicts with the idea of a quasi-judicial hearing rules for ex parte contacts. Essentially, she's hearing 2 separate hearings. She's listening to 2 separate hearings, or has that ability, and the other council members are discouraged from even attending the planning commission. So you know, that's the way it's set up right now, and you could see that after the first creation they had staggered terms. Now they are 3-year terms, and in the event somebody leaves the commission before their 3 years is up, then council appoints somebody to fill the unexpired term. As far as the duties of the planning commission, again, it's statutory and set forth in our code, and I won't go into every single duty that the planning commission has, but the main ones, the code says that the commission shall perform the duties and have all the rights, powers, and privileges specified and provided for by the statutes. One of the main ones is adopting a master plan, and this is one of the few areas where the planning commission actually takes formal action to adopt. It's not a recommendation to the city council, and that's for counties and cities, statutory and home rule. The legislature determined that it was important to have the Planning Commission adopt the master plan. Now, some communities, counties and cities have chosen to formally adopt, have their governing body, the city council or board of commissioners, adopt their master plans, and the statute even allows you to incorporate the master plan or portions of it into your regulations. But generally, a master plan is just a guiding document. It's not mandatory that you comply with every single portion of it, but it is a guide, and a lot of our regulations state that you should be in compliance with the master plan. Urban renewal plans, similar to master plans, are submitted to the Planning Commission, and the Planning Commission makes recommendations to the governing body or the City Council in the case of Cortez. And that's explained in more detail. In the Cortez Land Use Code, in Chapter 6, Section 6.01D, it describes the powers and duties of the Planning Commission. And it lists a laundry list of items that the Planning Commission does. I won't read through them. You all can read. And if you have any questions about any of those, certainly let me know. But there's a lot of stuff you do primarily as a recommending body to the City Council. You update the zoning map, and it requires review again and recommendation to the City Council for any changes to zoning. That would be either initial zonings or rezonings. And likewise, master plan amendments. The City Council actually submits those to the Planning Commission for a recommendation. The preliminary plats in the subdivision process are reviewed by the Planning Commission. That along with zonings and conditional use permits are probably the three primary functions that you're going to see come before you, and you review the preliminary plats and make recommendations. Moving on to planning and zoning commissions are subject to the open meetings law, and you may see Cheryl publishes the agenda at least 24 hours prior to the meeting date, and that's a requirement of the Colorado open meetings law. And planning commissions, even though you're primarily a recommending body, you still have to follow the rules of open meetings. And those can be rather tricky, and the statute goes into, it specifically talks about a local body, meaning any board, committee, commission, authority, or other advisory, policy-making, rule-making, or formally constituted body of any political subdivision of the state. So it's pretty all comprehensive in terms of public bodies, boards and commissions need to post their agendas 24 hours in advance, and that's very important. And it includes home rule cities as well as statutory cities. And a meeting is, for local bodies, it's the lesser of 3 members or a quorum. And in your case, 3 members is a quorum. So anytime 3 of you get together, you need to post it as a meeting. Now, excluded from that would be social encounters. So if you're not meeting to discuss public business, but you're actually just meeting to go through, Friday night cocktails at the local watering hole or whatever, you can do that. Christmas parties, those kinds of things. But if you're going to get together, even to talk about any kind of public business, then it needs to be posted 24 hours in advance. It needs to have an agenda. And if you discuss public business, minutes need to be taken. And that's a key point.
Can you speak a little bit about email communications and public open
Yeah.
meetings?
And one of of course, the open meetings law was created before there was email or texting, and but the legislature and the courts have addressed it, and if you get together via email, so one of you sends an email to all the other members saying, you know, I support this item, or I don't support this item, or any discussion of public business, that's considered a meeting. Of course, the problem is, how do you invite the public to attend an electronic meeting that occurs via email or text, for that matter? So I would encourage you not to ever email the entire commission. You can send an email without copying everybody else to me as the attorney or to Rachel, and Rachel can figure out how to transmit it back to you if the answer applies to everybody. It may have to be done at a regular meeting, but you've got to be careful not to conduct what essentially is defined as a public meeting via email or texting, for that matter.
Question? If we have questions on an application, are we free to discuss that with staff? That
Yes,
question?
individually though, don't
I understand.
copy all the other commission members, but yeah, you can communicate with staff. Two of you can actually do it, as long as we have a 5-member
No quorum.
commission. If one of you drops off and the council hasn't appointed a new one, then 2 would be a quorum, and so you couldn't do it. But yeah, you could copy one other commission member, and that's not considered a public meeting. But certainly individually, each of you can communicate with staff on any issue, and it won't be a public meeting.
So say we do that individually, and then someone requests through open records copies of any communication with any board members, commissioners. Would those emails then have to be
Well, there
part
are,
of-
and public records, open records is probably for the next training session, but I could tell you, when they first adopted what they call CORA, the Colorado Open Records Act, there were 5 specific incidents of exclusions to public disclosure. And the most obvious is attorney-client communication. If you call me or send me an email or a letter asking for a legal opinion, your request and my response is privileged, and it's not subject to disclosure to the public. There is also a exclusion or a privilege that's called the common law deliberative process privilege that applies to planning commission members and staff. If you are communicating about drafts of documents or things that might come up that maybe you say, hey, isn't this guy supposed to be in jail? How come he's applying? Anything that you intend not to be public may qualify for that deliberative process privilege. But it's, my advice is always pick up the phone. Don't leave a paper trail that we may end up having to get in an argument with a requesting party about whether or not it's subject to disclosure. But yeah, there are some exclusions, and personal financial information from, you know, a member, an applicant, or obviously staff or commission members, phone numbers, you know, private phone numbers, social security numbers, anything like that is excluded from public disclosure. But yeah, and certainly if you have a question, you know, call or email me first, and I'll let you know whether what you're proposing to do would be subject to public disclosure. And on that note, and I haven't seen it since I've been here, but I have participated in what they call executive sessions at the Planning Commission level. It doesn't happen nearly as often as with the councils or boards of commissioners, but the open meetings law allows you, if you want to consult with the city attorney, you can do it, and it doesn't have to be posted on the agenda. You can, you know, any member can ask the chair and say, you know, Mr. Chair, I request that we adjourn into executive session so I can get some legal advice on a topic related to this application. And if you want to do that, I've got some forms that I can give you that will give you the specific language you need to use in the motion, because it has to, you have to go into a motion, and it has to be a 2/3 vote of the quorum that's present in order to go into an executive session. But there may be times where you're confused maybe about something an applicant or a member of the public said, and you want to know, is this legal, or can they do this, that sort of thing, and you want to discuss it with me, but you'd rather not have an open discussion and get legal advice in front of everybody else. And it's definitely appropriate for you to go in executive session. And some communities, they have the room vacated. They send the public out. We don't do it that way, fortunately. We have a room back. It's the jury room to the court, and that's where we hold executive sessions. And so if somebody wants to do an executive session, I could give you the script for the motion. And you know, there are other issues related to personnel and those kind of things that probably don't come before the Planning Commission. The main one I could see that you might want is conferences with an attorney.
And isn't there a special statute that you have to refer to in the motion when you make that?
And you have to be detailed. And so I've got, and the mayor knows this well, we have specific statements that you have to make in the motion and then during the executive session. And so it's very specific on what has to be said. And but you know, like I said, I don't recall, and Robert, you've been on here many years, and have you ever done an executive session with the Planning Commission?
Only with school boards when I was superintendent would we have to go. Now, do you have to keep minutes of these executive sessions?
Yeah, you keep minutes, and you can record it rather than make written minutes. And if it's a conference with an attorney, then you turn the recorder off. Now, if you deviate from seeking legal advice and then receiving legal advice, and you start talking about other policy-related issues or things that aren't considered attorney-client privilege, then you got to turn the recorder back on. But you know, the idea is that if it's not attorney-client privilege, the discussion, then if somebody thinks you deviated from the statement that you made in the motion, and it could be one of the members of the commission can say, hey, they're going above and beyond what they said this was about, they can challenge it, or a member of the public can challenge it. And the remedy is that you go before a judge. The judge goes in chambers and listens to the recording and makes a determination as to whether or not the commission was in compliance with the the motion and the open meetings law. But certainly, you know, when I'm in there, I work pretty hard to try to make sure you stick to the purpose of the executive session, and so that we don't have to worry about that.
And no decisions are made in executive
Yeah,
session?
and there are specific rules. You can't take any formal action. You can't make a decision. You can't vote on anything. You know, in terms of legal advice, you can receive the advice, you can ask for the advice, but they get fairly specific about it. There was a case that just came down about, maybe 2 months ago, where the commission actually, it was actually a city council, directed their attorney to do something. And somebody challenged it and said, hey, you took a formal action by giving direction. And it's a difficult law, because one of the exclusions or the reasons for executive sessions is to give direction to negotiators. So if you're looking at buying some property, and this would generally be the city council, but you know, they could give directions to negotiators, like say, you know, offer X and don't go above Y or something like that. The argument could be made that they actually took a formal action, even though they didn't vote. They just kind of looked around the room and said, anybody disagree with that? And so it's becoming more and more difficult. And of course, the main premise of the open meetings law is that the public's business should be done in public. And so, you know, I think if in doubt, we should hold the meeting in public, and rather than doing it in an executive session. Now, the statute does have some specific things that you can't do in public. And so, you know, we need to be sure that we're not, you know, violating those things. And, you know, the most obvious one is if you're going to discuss personnel matters relating to a specific employee, you can't discuss it in open session unless the employee requests to have it discussed in open session. But there are other examples, but nearly all of them would not be applicable to what the Planning Commission does. So, just kind of getting into the next topic, there are types of meetings, and the main ones, legislative hearings or legislative meetings, and that's where you discuss items and you take actions related to adopting policies and rules and legislation that is applicable to the entire city or large portions, large numbers of properties and large numbers of people. And then the other type is a quasi-judicial hearing. Now, a legislative hearing, those of you that were on last year, in 2023, you made recommendations regarding the housing policy. You made recommendations regarding regulations for mobile food vendors in the Central Business District. Those are all legislative actions, and the main difference is that a legislative action doesn't require what they call a public hearing. Now, you have a meeting that's been posted to the public, and the public attends, and you know, they are allowed to comment. But with quasi-judicial hearings, it's much more specific, and it applies to individual properties or individual persons, and you're essentially applying the legislation that you've made recommendations and the City Council has adopted, or in the case of the master plan that you have adopted. And You're applying that to a specific person or property. And with a quasi-judicial hearing, you are sitting more in the form of a judge rather than a legislature. And the key distinction is in quasi-judicial hearings, you're supposed to receive all the input on that application during the public comment portion and, well, in the public hearing, so that all of you are receiving the same input, and you're not supposed to be getting input outside of the public hearing. So in other words, in a legislative capacity, you can go to League of Women Voters or the Rotary Club or the local cafe and get all the input you want from friends, neighbors, the public, applicants. You know, you can receive that information, and you're actually encouraged to get as much information as you can before you vote on legislative matters. Quasi-judicial is the exact opposite, and if you have contact with anybody who wants to discuss a pending application outside of the public hearing, you should decline and say, I'm not allowed to discuss this. If you have written comments, send them to the planning, I guess. Do you receive those, Rachel, or is that the clerk?
Public comments?
Yeah.
I don't think I receive them directly.
So just tell them to send it, you know, if it's an email or a written letter, send it to the clerk. If it's, you know, or if it's pictures, they could send it in ahead of time. If you are wanting to, or if they are wanting to speak verbally on the issue, tell them to show up at the public hearing, and they can get up here at the podium and speak to you. But the key is, and it's tough, because in a small town, you know, most of you probably know a lot of the applicants, or you know somebody who knows the applicant, and people in a small town want to talk. They see you at Walmart, or they see you at the coffee shop, and they want to give you input. But you need to be very strict and say, you know, I really can't talk about this. I'm not allowed to predetermine my position until I've heard all the evidence and testimony at the public hearing. And the reason it's bad is somebody can appeal a decision if they feel that they've got proof that one of the people voting on that application had ex parte contact and didn't disclose it and didn't describe it. Now it's one way to kind of get over if inadvertently you received information from a member of the public. You can disclose it at the hearing, but you need to be real detailed so that your fellow commission members are essentially hearing the same input that you received through the ex parte contact. So if somebody corners you at Walmart and says, you know, this thing's going to ruin my business and whatever, or I think it's great for the community and you need to approve it, you need to describe what you heard, and you can say, inadvertently I had ex parte contacts, this is what occurred, and be specific as you can. And so that way everybody's basically dealing with the same set of evidence and testimony when they go to vote. But if somebody can prove that you had these ex parte contacts and didn't disclose them, they can appeal what they call a rule, through a Rule 106 action, and a court can overturn the decision if you didn't follow the rules. So I tell people that you really need to you know, follow that. And you know, with a quasi-judicial hearing, it's if it gets appealed, they don't re-argue the case in front of the district court, the record of the hearing is presented to the district court, and you make a transcript of it, and they can hear the verbal, if you have it recorded verbally. So it's very important to make a record, and that involves making sure that anybody that is going to comment comes up to the microphone, states who they are. I don't recommend that you require them to give their address, but you could say, you know, let us know what community you live in. So if they're from California, they're still a member of the public. They have a right to speak at this hearing. But I think in today's age where, you know, people might take it out on somebody if they disagreed with their position, and forcing people to give their home address is probably not a good idea in order for them to speak publicly. But you can ask them, you know, are you a resident of Cortez or Montezuma County or Colorado or whatever, but you need to make that record. And so as the chair, you want to make sure that people aren't speaking from the audience, and whether that be staff or the public. If somebody starts talking from the back row, interrupt them and say, please come to the microphone and state who you are and give your input, because that way it's on the recording, it's part of the record, because the microphones won't pick it up if they're sitting out in the audience, and that goes for boos and cheers as well. So now generally you don't want them to boo or cheer, but that's why we have the podium.
So let me ask you a question on that. So who does that? Just the chairman admonishes the audience, or I do, or I tell the chairman to, or how does that work?
Well, generally the chair should control the meeting. If you think that the chair's not acting, you can address the chair and say, Mr. Chairman, I think we need to make sure that these people properly follow our rules of decorum and come to the microphone and speak. And you could give suggestions to the chair, and I'm sure the chair will welcome any suggestions.
Yeah, wouldn't it just be a rise to point of order,
Yeah,
Mr. Chairman?
just a
and you
point
need
of
to-
order, and
yeah, okay.
you can ask for one.
Yeah, I know, and years ago, even on city council, we used to have them give their address and stuff, and when I became chair, I quit doing that because Halloween was close, you know.
Oh, yeah.
So I quit
Well,
asking for their address.
You see it on the national news now. Of course, somebody that's halfway talented with the internet could find where you live anyway, but forcing them to announce it in a public hearing where, you know, tensions are rising, and, you know, we've seen, what do they call it, there's a term for it where they make
Stalking.
yeah, they make fake calls saying, hey,
Oh, yeah.
there's some gunshots at so-and-so's house. Here's the address, and, you know, it's fake, and the SWAT team shows up with guns
Yeah, it's
drawn.
called swatting.
Yeah,
Swatting.
that's it, swatting, yep. And we've seen that, you know, just recently in some of the national news. So, yeah, I would suggest, you know, make a record, but I don't think you need to require the applicants to say their specific home address.
And this refers to zoning and rezoning applications, but what about conditional use permits?
Yeah, and conditional use as well. You want to make the record for that and follow the public hearing, because essentially it's changing the use of the property. And that's a type of zoning. So I would definitely recommend it. Let's see. In slide 16, I've given a couple examples of what a disclosure might be if you did have ex parte contacts. One of them would be, I have to disclose that I was contacted by several of the neighbors opposing this application, and they provided me with information about decibel levels of noise and, you know, showed me statutes that regulate noise and that sort of thing. And so you want to disclose that. And if they gave you written information, you should have staff make copies of it so it can go to each of the commission members before the hearing. And, but I think that's the key thing is try not to have ex parte contacts. It's just a lot easier to not give opponents of your decision, let the camel get its nose under the tent in terms of an appeal. So avoid those ex parte contacts. The final issue I just wanted to mention is, you've probably been to most hearings where the city attorney is present, and a lot of people don't really know, well, how is the city attorney appointed or hired or elected? People, unless they're involved in it, they really don't know. So there are statutory provisions and in the Cortez City Charter that require the city to appoint a city attorney, and it's the city council that does that, and kind of specifies their functions. The statutory provision just says the city council shall appoint a city attorney who upon taking office shall be an attorney at law licensed to practice in the state of Colorado. So they didn't go overboard with qualifications other than you got to be a licensed attorney. I think our charter says you got to have 3 years of experience, but obviously I'm thankful that this city council wanted more experience than that, and I qualified for it. What is the role of the city attorney? Essentially, in your context, it's primarily advising you, giving you legal advice on the code and the law in general, and different things that can come up during a meeting, the procedural aspects. And you see a quote from Justice Scalia says, "The main business of a lawyer is to take the romance, the mystery, the irony, and the ambiguity out of everything he or she touches." I'm not sure we all accomplish that on a regular basis. But the other question is, what do city council members and P&Z members believe is the role of the city attorney? And J.P. Morgan, one of the robber barons of actually 2 centuries ago now, he said, "Well, I don't know as I want a lawyer to tell me what I cannot do. I hire him to tell me how to do what I want to do." Unfortunately, I think as a local government attorney, we're often required to tell our clients how to not do what they want to do, because if they're straying from what might be considered legal, it's our job to point it out and explain that to them. But I guess with that, I will ask if you have any other questions, and that's all I had for today.
Yeah, I have one question, but thank you for putting this together for us and doing the training. I do have a question, is going back to the original 5 members on the council. I assume we're maybe term limited?
Yes, so they, no, there's not, I don't believe, Rachel, there's no term limit for P&Z.
I don't believe so either. That's something that council was discussing as far as just overall, should there be term limits, and if so, what those should look like. I mean, there's, what is it, you're appointed for a certain number of years, and then you have to be reappointed.
Yeah, reapply.
Do we have any idea who is on what year terms?
Yes. Our city clerk keeps track of that. I don't know off the top of my head, but we have, yeah.
And it's all, even though the initial planning commission had staggered terms, all of you are on 3-year terms unless you were appointed to replace somebody who left the commission, in which case your term coincides with the original appointment. So at the end of the original 3-year term of your predecessor, you would have to reapply if you wanted to stay on the commission.
So basically, there's no 5-year term
No.
person?
No.
Okay.
And it's yeah, that was just so they wouldn't have everybody on the initial commission leaving at the same time. They wanted to develop some historical, institutional knowledge. And so now we've got it staggered. It's still staggered, but they're all three-year terms.
Okay, yeah, I guess if I had read a little further there. I was panicking that 5 years.
Yeah.
Okay. Anybody have any questions for Patrick? Okay,
All
thank
right,
you.
well, thank you.
Let's see. Do we have any other unfinished business?
Can I just give a quick reminder to folks?
Sure.
So next Tuesday, in fact, at 5:30, I know, I didn't send out a calendar invite this time because some folks' calendars actually give you the wrong time, but there's a joint P&Z and council meeting at 5:30 next Tuesday.
Yeah, and that's with the land use code people?
Yeah, we're going to be discussing land use code, so we'll get some information out to you on that, hopefully by Friday. So we're keeping you busy.
Ooh. Oh, yeah, the 23rd, right?
Yes, 23rd.
And I had mentioned to Bob that since he's new, that if in going through the code, he sees things that don't make sense to him or that are confusing, to let Rachel know, because we're still, nothing's been adopted yet. So if we find things that are not user-friendly or just don't make sense or conflict with other provisions, we need to know about them.
I've been making notes.
Yeah, we'll accept your laundry list, so please send it.
Anything else for the good of the order? Then I'd entertain a motion to adjourn.
Motion to adjourn.
Second.
Got a motion and a second. Any discussion? Let's proceed to vote.
Scorts,
Yep.
Bright,
Yes.
Weiss. Yes. Ramey.
Yes. Meeting adjourned.